UAE introduces new laws for non-Muslims regarding marriage, divorce and inheritance. Introduction. The introduction of a new personal status law for non-Muslims is a landmark decision promulgated by the UAE government that has come into effect from February 1st, 2023. The Federal Decree Law No. 41 of 2022 on civil personal status brings several changes in terms of marriage, divorce, custody, inheritance matters for non-Muslims in the country. Following the issuance of the Abu Dhabi Personal Status Law for non-Muslim foreigners in 2021, the federal government came out with a personal status law that would apply to the entire non-Muslim population of the UAE, for both citizens and expatriates. In this video, we'll discuss in detail the many changes that the new law entails, including topics about civil marriages, divorce and alimony, child custody, and inheritance matters. Which type of matters are exclusively dealt with in the new law? The new law specifically recognises civil marriage contracts, exceptions from family guidance mediation, equal rights and duties for women, divorce and alimony, child custody and proof of parentage, inheritance and wills. What is the scope of application of the new Federal Personal Status Law? Article 1 of Federal Decree Law No. 41 of 2022 applies to the following. A. Non-Muslim citizens of the UAE. B. Non-Muslim expatriates and residents of the UAE, unless one of them opts that the law of their own country be applied in matters related to marriage, divorce, inheritance, wills and proof of parentage. Section 4. Choice of law for non-Muslims and expatriates. Under the new law, non-Muslim expatriates are given the option to choose to apply the provisions of the new law or those of their home country's law. This option also existed in the Personal Status Law of 2005 and has been incorporated in the new law as well. How does the new law differ in terms of marriage? The new law introduces the concept of civil marriage for the first time in the UAE. Under Articles 5 and 6 of the law, non-Muslims can get married without the requirement of a guardian's approval or a pre-marital screening certificate. What are the primary conditions required for civil marriage in the UAE? 1. The age of both parties must be at least 21 years. 2. There should be free consent of the parties to the marriage. 3. Marriage should not be within the prohibited degrees as stipulated. 4. The party should not have been married to someone else. What is a no-fault divorce? According to Article 7 of Federal Decree Law No. 41 of 2022, a no-fault divorce is one where either of the parties does not need to prove damage to file a divorce. Either the husband or wife can file for divorce without proving fault on part of the other, or any other reason for justification. Changes with the Family Guidance Committee and divorce matters. Article 3 of the new law states that the parties applying for divorce under the new law will no longer be mandated to go through the procedure of amicable settlement in front of the Family Guidance Committee, and the divorce will be taken up by the court of first instance directly. However, for those governed by the Personal Status Law of 2005, it is compulsory to resort to the Family Guidance Committee before approaching the courts. The wife's share as per the inheritance provisions under the new law. The new law states that a wife is entitled to half of the estate upon death of her husband. Further, there is no distinction between male and female heirs, and no restriction on how much estate a person can bequeath in a will under the new law. Section 9. Alimony calculations under the new law. When a divorced woman files for alimony and the marriage contract doesn't include the terms of alimony or any other financial agreements, the subject will fall upon the discretion of the judge. Following Article 9 of the new law, the judge will decide alimony based on the following factors. A. Number of years of the marriage. B. Age of the wife at the time of the divorce. C. The financial status of each spouse. D. Husband's contribution to the divorce. E. Compensation paid by either of the spouses for any damages inflicted on the other. F. Financial loss suffered by either spouse as a result of unilateral divorce. G. Whether the mother is diligent towards children. The alimony will be forfeited in cases of the following. A. The woman marries another man. B. The custody of the children with the mother ends. Joint custody after divorce. As per the new law, both the father and the mother are given equal custodial rights on their children. In addition, it is the right of the child or children to have both parents raise them, to minimise the psychological effect of divorce on them. Article 10. The primary rule in terms of custody is that the father and the mother shall have joint custody over the children. However, the court may maintain an application by either party. A. Of granting custody to whoever is capable of achieving the best interests of the child. Or B. Seeking to waiver the right of custody. Or C. Excluding the other party and forfeiting the right to custody because of non-eligibility, the danger of such custody, or the party failing to perform their duties. In cases where joint custody is disputed, the court will have discretion in the decision, keeping in mind the best interests of the child. Overall, the new law is a welcoming gesture in the adoption of international best practices.
For more of our latest updates, like and subscribe to this channel.